complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have the chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not protected. To the best of my knowledge, the business of the day, there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes. Yes.
My lord, you're being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you're being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, Dedo and my friend Kibe, is that you are taking the court for a long ride and we're ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you say?
My lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My name is Manjur Mondi. I am acting in person. We filed an application for certificate of urgency on the 8th of October, 2024. Before this bench was in panels on the 15th of October, 2024. Unfortunately, some of the grants we were seeking have been overtaken by events. And today, as you have heard, our application has not been placed before you, and we are just concerned that our application will once again once again overtake our application, my lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
But actually, for the 15th of the party in 15, I guess we had for 1 minute on. My Lord Jadra asked an important question. How do we move forward? But the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Bremer about how these pains have been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction of the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if you follow that suit, in accordance with my teacher's guide and Professor Gidumwe guide, there will be greater order and coherence. And I thank you.
But Lord, is that an adjournment? Is that if it's a lawyer applying for an adjournment? Because he's saying, and perhaps rightly wrongly, that even the refusal application comes after the termination of the question of empanelment. If that be so, they may leave, they normally leave court, they may leave, they left the Senate, may leave court. Let them say whether they are applying for adjournment.
Is that remark they normally leave court, the left Senate, my palatable in this court, my Lord? I mean, that
No, because it's an adjournment.
No, is that remark palatable for my Lord and my Lady? But because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my Lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My Lord,